Have a seat, please. All right, we'll consider our final case of the day, Samuel Johnson versus NANDKISHORE RANADIVE, MD. RANADIVE, right. Tell me if I said that name right.
Good morning, Your Honors. I think it's RANADIVE. That's how we say it, but it...
That's
RANADIVE. Okay.
Alex Finch on behalf of the appellant. Initially, I'd like to thank the court and opposing counsel for allowing me to appear on behalf of Mr. Wells due to his family emergency. I was not trial counsel, but I have reviewed the file. I'm familiar with the procedures of the court and with the area of law. I may struggle a bit with facts, and I request the court's indulgence. I only got this a little while ago. The facts in this case are really simple, and they're not in dispute, so I won't belabor that for the court. The main issue is the issues of law that have risen between the two parties, trying to determine whether or not there's a viable cause of action legally to which to apply those pretty much undisputed facts. The plaintiff has filed, at a lower court action, filed a motion for leave to amend to assert common law causes of action. Prior to that time, there had been a statutory cause of action under the HIV statute 381.004. There was a battery claim, there was an a libel claim based on poor incorrect notations in a record asserting that the plaintiff was an HIV positive individual. The court, through the course of the proceedings, got rid of those cases, saying that the statutory HIV statute did not apply because the defendant doctors had not ordered a test. And a lot of the statute goes through the testing procedures and what happens. But the second part of the statute says, what do you do once you get a positive test or a negative test, and confidentiality requirements for disclosure. It is the plaintiff's position that that statute and that portion of that statute would apply to statements made within the record asserting that somebody is or is not HIV positive. Once it's in the record, there's a duty of confidentiality that should not be disclosed.
Well, counsel, I guess the kind of gut level issue here is, where was the publication?
It's the plaintiff's position that it was published when published into the record. The defense, both of the defense, assert that when you write something, the medical record.
This court?
No, sir. When it was published in the medical record of the plaintiff.
But I thought those were confidential.
There's no. They may be confidential, but it's breached if it's given to other people within the hospital, for instance. It's hung on the end of the bed. Anybody can read it. There's special protection that has to be given to HIV-related records for obvious reasons that are put forth within the statute. It has a terrible stigma to it. People won't go get tested if people are going to find out they're being tested for it, much less having it. So you have to protect the records. In this case, it was put within the medical records from the initial entry into the hospital, with the plaintiff never saying he was HIV positive and no one testing him. They carried it forward as each doctor saw them. They took that and never inquired as to his medical history, whether or not he was HIV positive. And later it got about the entire hospital and later undisputed into the community that he was HIV positive. After he indicated he was not HIV positive.
How did it get into the community?
Through individuals that came in contact with it in the hospital when it wasn't properly protected as confidential information.
Well, shouldn't they be the ones you sued, and not you, but should they be the ones that the plaintiff below sued, rather than the doctors who signed on to this confidential document?
The plaintiff would certainly know, because one, when the doctors put it in, they had a duty to our client to protect it. All the staff members that worked underneath the doctor and giving blood, performing the care that the doctor required, was also subject to responsibility. It's our position that the plaintiff, the defendant doctors, had a obligation and a responsibility for their actions working underneath the direction of the doctor.
isn't it the hospital's responsibility to maintain, they're the custodian of those records. And, you know, the people that draw the blood and process it and all that, they work for the hospital. They generally, I mean, this may be an exception, but generally they don't work for the doctors. It seems to me that the problem, I guess, is doctors erroneously put that he's HIV positive in the records, and from there on, I'm trying to understand, you know, what the doctors did other than putting that in the records. What did they do to release or fail to safeguard the information? The hospital may have done it.
No, I'm sorry, Your Honor. I thought you were finished.
Go ahead.
Okay. It's a plaintiff's position that they put it in the record, and at that point, whether it was true or not true, they had a duty to keep it, the doctor themselves. They're the ones who order the tests when they occur, and they're the ones who have the information put in the files once it comes back from the laboratory or whoever has done it. That file does belong to the hospital. It also is a medical record of the doctor in his office. He can take things out, he can put things in, he gets copies,
But there's no evidence that that occurred. I mean, your view of the evidence is that if there was a breach of confidentiality, it didn't come directly from the doctors. The doctors put the information in the records, but to the extent that there may have been a breach of confidentiality, there's nothing to suggest that the doctors went out and spoke of this in the community or spoke of it outside the medical context, is there?
No, that's correct, Your Honor. There's no allegation anywhere in the lower court that the doctors published it directly to a third party outside of the hospital community.
Is it your view that putting it in the medical record, let's assume that it never had gotten outside the hospital. It just erroneously goes in the medical record, and other people within the hospital context see it, but they don't go talking about it out in the community. So it stays within the hospital. Would that be publication by the doctor?
Yes, to the extent that any person not within the direct authority of the doctor heard it and it had an effect on those people to shun the plaintiff. In this case, is what's happened. They were standing out, the candy stripers, for lack of a better term, the janitors, the maintenance people who are not responsible for being in and out of the file, were openly discussing plaintiff's alleged HIV positive status. Is the plaintiff's contention that because this particular type of record is so private and the chance of being harmed with its disclosure is so great that they've created a statute to try to avoid the stigmatism, places a greater duty of confidentiality and protection on the doctors? If the court ruled that if a doctor puts it in the record and then their nurses go off and say it, you could never find a doctor liable. They've got to be responsible for the people that work. It's the plaintiff's position.
It seems to me that the statute is designed to prevent breaches of confidential information, not to prevent ordinary errors in the creation of medical records. Aren't those really two different things? I mean, we've got two problems here. One is that the doctors erroneously put something in the record that doesn't belong there. But then you've got somebody that's going out and disclosing this. I don't know exactly who, but somebody is running their mouth about this. It seems to me that the breach is in the disclosure, and I'm having a hard time understanding how the statute that deals with improper disclosure is violated if by merely the creation of an erroneous record, assuming that there's no malice and that sort of thing. I mean, it's just an ordinary error.
Well, first, the plaintiff would pretend that labeling somebody as HIV positive without doing a test for it isn't an ordinary error. The statute, by creating it and giving it a heightened status, I think takes it out of an ordinary error. Second, the argument below wasn't on where they're asking for leave to amend to go under the statute. It was to go under common law confidentiality.
All right, well, let's talk about that. Tell me what torts you think were committed by these physicians?
As pled, Your Honor, and the leave to amend, it was straight negligence, civil negligence, based on the Gracie Supreme Court case and the Averill case. Secondly, the tort of intentional emotional distress. The defendants have argued that there's an impact rule barring it, but there's, again, I believe the Gracie and Averill say that doesn't apply when you have a breach dealing with highly sensitive information. In Gracie, it was a psychologist.
Okay, so we've got negligence, intentional infliction of emotional distress. What else?
I believe, Your Honor, that they tried to reallege a battery and liable against Dr. Nelson that was previously dismissed. I don't know that that's viable. If there was a dismissal completely as to that defendant as to prejudice it wasn't appealed, that may have been waived. But as to the remaining doctors, they carried forward the statutory claim in an attempt to ask that statute be interpreted to cover disclosures of information relating to HIV, regardless of whether a test was performed to create that information. The two negligence causes of action against each one of the two doctors that carried forward the information, and then the intentional emotional stress. Those were the three common law causes of action added, again, reasserting the statutory action.
The third comment, we've got intentional infliction, we've got negligence. Are you,
two negligences.
By three, you're talking about two physicians. One for each physician.
Right, as to the
and then
negligence.
Intentional infliction.
Yes, ma'am.
Okay.
Yes.
Well, let's talk about the common law negligence then. What is the theory of common law negligence that you contend the trial court should have allowed?
Well, the court knows the elements of negligence, but we assert there's a duty.
A duty to do what?
To hold confidential private information gained from a plaintiff in a fiduciary duty. That's what Gracie stands for. If you give information, or if information is obtained from a plaintiff that is of a confidential and sensitive nature, you have a duty to protect it. That Gracie was carried forward into Averill. I believe the underlying court case in Gracie here was a 50CA case where Judge Antone said, well, since we don't have a statute saying there's protection for that kind of confidential information, then there's no per se violation. Went up to the Supreme Court and they said, no, we're not going to agree with that. If you give confidential information, and this was in psychotherapy kind of situation, and then you tell them you breached your duty to your client. And it's a civil negligence breach, not a medical malpractice claim.
We don't have a breach of confidentiality by the physicians themselves.
That's not the appellant's position. As argued in reference to Judge Orfinger's question, we believe that once they got that information, even though it was errant, that it has a heightened level of confidentiality based on its nature, and the doctor had a heightened level duty to protect that from everyone. It wasn't protected. It was placed in a chart and set on the bed. Anyone could see it, and everyone did, apparently. It became common.
So your contention is that a physician has a duty, because of this confidentiality, not to record facts in a chart?
No, Your Honor. Once it's recorded in the chart, to protect that chart from prying eyes, from passing eyes.
So their negligence in this case was the failure to keep the chart sacrosanct from somebody.
Prying eyes.
Okay.
Yes, Your Honor.
Prying eyes. Do we know whose eyes actually pried?
The evidence says that the staffers within the hall were discussing it. There's an inference there that it would... The record does not reflect who disclosed the information from the chart to a third party outside of a nurse or a doctor. There's no... I couldn't find it, and I imagine the appellees will say it doesn't exist.
So we don't know that the person who disclosed the information wasn't someone authorized to see the chart.
I believe that's correct, yes.
If we don't know that, how can you prove the physician's liable for breaching their heightened level of confidentiality?
It's our, again, in response to Judge Orfinger's question, it's our belief that they're responsible for the acts of the nurses carrying forward their orders and giving services. Judge Orfinger says, well, that's a hospital because that's a hospital employee. We don't believe that's how it should be interpreted. We
Well,
believe
you've got to
that,
explain that to me. Given the facts of this case, what did these physicians do? If we don't know who disclosed the information in the chart, how can you ever prove that there was a breach of the duty of confidentiality?
because it is our position, Judge Griffin, that A, how did they breach? One, they put it in there. Two, they never found out.
But putting it in there
Well,
that's not alleged.
No, I understand
That's
that.
not the problem. The
I understand that,
problem
Your Honor.
is that somebody saw it and somebody's eyes pried and the information got out. But if you can't prove whose eyes pried and that the information got out, how can you ever prove that the doctors committed a tort?
Well, first of all, there's separate torts, one requiring publication and one not requiring publication. meaning the
I'm
intentional
lost
emotion-
on the publication.
Well, I understand-
Your theory is that the physician had a duty to keep the documents at some level of confidentiality so that unauthorized people didn't see it.
For two of the claims advanced, yes, Your Honor.
Okay, all right, let's stop there. But you don't have any evidence that an unauthorized person did see it.
No, I don't think that's true, Your Honor. We have evidence that people within the hospital that were not primary caregivers were discussing it, so they did receive it. The question is, where did they get it
We know
from?
who received it. We don't know who took it. We don't know that an unauthorized person looked at the chart, do we?
No, what we do know, Your Honor, is that it was put in a chart and someone, other than the doctor, disseminated. It was either an unauthorized person who got access to the
But
chart.
by definition, charts are designed to communicate information. The only theory you can possibly have is that there was a duty on the part of the physician not to allow any unauthorized person to look at it, and that an unauthorized person did look at it in violation of the physician's duty of reasonable care.
Yes.
But you've got no evidence that an unauthorized person did look at it.
We have evidence
And
that...
you didn't plead it, and you don't even have any evidence of it, do you?
No, I would disagree with that
What
statement.
is the evidence that an unauthorized person looked at it?
No, I misunderstood the question the judge just asked. Our evidence is, A, there's disclosure. There are only two kinds of people who could have disclosed it, an unauthorized person or an authorized person. I'm sure the court, those are the only two that are left. Either a nurse that was or some party was authorized to be providing care told somebody, or they didn't protect the record and allowed it to be viewed by an unauthorized person who told somebody. Just like putting it in a fax machine and not sending to a secured fax facility, for instance. So we have a disclosure. That isn't the issue. The issue is how to get there. One of two ways. Our position is, either way it got disclosed by one of those two categories of people, it was the doctor's responsibility to make sure it didn't happen because of the confidential nature of the records.
But if a person authorized to see the chart made the disclosure, how did the physician breach his duty of care?
I believe the appellant believes that it's the duty of the statute's pretty clear. It's the one who gets the test, gets the information, has to make sure it's not disseminated, whether by the secretary sending it off to the lab through an unsecured facsimile.
It's not a negligence theory. Is it a negligence theory?
Yes, they were
It's a
negligent.
reasonable care standard then.
Yes, it's not a medical malpractice
How did the
standard.
physician breach his duty of reasonable care?
He
How
didn't
was
use-
his care unreasonable?
He didn't use reasonable care, at least within the record, to prevent disclosure of that record.
How do we know
authorized to
that?
his office. Because people are running around talking about it, Judge.
So it's not reasonable care, it's not negligence, it's strict liability.
No. It's reasonable care. Did he give any information to his nurses that this has to be closed and not shown to other people within the hospital? Did he tell people, you're not allowed to look at this record? There's no evidence of that. There's no evidence that he did
Mr. Finch, doesn't that really beg, I mean, in the real world, the way hospitals work, is that the maintenance and retention and disclosure of medical records is a function of the hospital, mean, I can understand if the doctor had taken the chart and written on the outside HIV positive and hung it out there so that he disclosed it to everybody that's walking down the hall, that might be a different story. But if he merely puts that in the physician's notes, and we assume that, you know, if I'm just walking through the hospital to go visit a relative, I shouldn't be, and the hospital shouldn't leave the record laying around where anybody can grab it. I'm having a hard time understanding your theory as it relates to the physicians vis-a-vis perhaps the hospital didn't take precautions. I mean, if we were to adopt your theory that if there's 500 doctors on the staff, they might have 500 different views of how these records ought to be maintained. And I don't know how a hospital could ever function that way.
My time, do you want me to respond, Your Honor?
Answer that question, and then time's up.
Okay, thank you, Your Honor. That's a pretty big question, but...
well, if you got 500 doctors,
no, I understand the
says,
question,
look,
Judge.
we're going to lock this thing up in a safe in Nevada so nobody ever sees it. And at the other end of the extreme, doctor number 500 says, we're going to put it on a billboard outside. You know, how's a hospital supposed to function if you've got 500 guys or girls saying that we're going to keep it in 500 different ways?
I think the key to that, the only answer to that, in my view, Your Honor, is you have 500 doctors, but not all 500 are dealing with statutorily protected, confidential information that carries a severe public stigma. I don't believe that it would bring a hospital to the halt or a medical records process to a halt to have a process where that stigmatized information is made protected from all. That's what the statute requires for obvious reasons, so people will go get tested and we have public health. It's not an unreasonable burden. It's placed on them by the statute. They have a duty of confidentiality just through civil causes of action under Gracie, and it was reckless and irresponsible to put it in there, to not change it when they found out it wasn't the case, and then to not tell someone, you can't tell anybody about this. That's what the statute asked them to do, and if 95% of the records in the hospital were HIV positive, I would believe, I would probably fall in line with Judge Orfinger that this would be an unworkable sort of thing. But I don't believe that's the status of HIV patients within a hospital.
Okay, thank you,
Your
Counsel.
Honor.
You're 2.5 minutes over, so in fairness, we'll subtract 2.5 minutes from the time that the appellees have, and they'll only have 17.5 minutes to argue.
Okay, thank you, Your Honor. Wow, I didn't mean to do that. I'm sorry.
Well, you were using their time, so it's only fair.
Alex, I liked you a lot up until then. I don't know.
Sorry about that.
That's all right. Good morning, Your Honors. My name is Jack Holt. I'm here today representing Dr. Adamali Adewale, who's an emergency room physician. I heard that a lot of the questions you were asking were about whether or not it was appropriate to let the plaintiff amend in this case. I don't want to ignore the other two issues, but I do want to address some of the questions that you asked the plaintiff's attorney. First of all, Dr. Adewale is a physician only in the emergency room at the hospital. He has no jurisdiction, in a way, over a patient once they're admitted to the hospital. His sole role is to deal with the patient as they come into the emergency room and try to get them to the best available care for their emergency condition. If you look at the facts in this case, that's exactly what Dr. Adewale did. Within 7 minutes of the triage nurse making an inappropriate notation that the patient had HIV, Florida Hospital's nurse, not Dr. Adewale's.
Do you know how that happened?
I only have speculation, Your Honor, because we never took the testimony of the nurse, but the block for arrhythmia is directly above the block for AIDS, HIV, and I have the suspicion that possibly she just checked the wrong one by mistake. But I can't, that's not in the record, Your Honor. If you go, however, you can see what I was talking about if you go to the record at 223 or the record at 197. Either one would show you that that is what happened, or at least that the hash mark was there. Within 7 minutes, Dr. Adewale saw the patient. He copied over the information from the triage nurse. And I want to make that clear, that he copied information that was given to him by another individual. He did not create the information himself. Whether it was false or true or not, what he did was copy it over into his own notes of the interaction.
Is there a different standard of care for emergency room physicians as opposed to regular staff physicians?
Actually, Your Honor, by law, there is a slightly different standard of care which is set forth in Chapter 766. But in the context of this issue, of whether or not you should rely on documentation by previous healthcare providers, I think the standard of care is exactly the same, that Dr. Adewale accepts that information but then makes his own examination. As Dr. Adewale completed the examination, as his affidavit shows, he became most concerned about cardiac care of this patient. HIV, even though it was something he copied over, ceased to be an important concern of his during the examination and evaluation. And he made that very clear during his affidavit. In fact, in response to that, he enlisted Dr., and I've always pronounced it RANADIVE, but maybe I guess it is RANADIVE, was exactly the cardiologist he needed to get to help this patient. So putting this communication in context, it's clear that the communication is part of a common purpose. The hospital's common purpose in helping Mr. Johnson get the care that he needed. It was not a publication to the community at large. It's interesting that publication comes up in both contexts because something that's very important here, even if the allegation had been true, in other words, if Dr. Adewale had correctly noted that Mr. Johnson did have HIV, the plaintiff would still be saying he lit the match that started the fire when the nurses, somebody not within Dr. Adewale's control, revealed the same information to the community. Because if you look at Abril and DEW versus Krause, a case that came out since that time, you'll see that disclosure to the outside world is what's relevant to creating either a cause of action under Gracie versus Eaker or under traditional libel law. And that simply did not occur on Dr. Adewale's watch. Moreover, in this case, and I want to address the intentional infliction of emotional distress just a little bit. I think the case law is clear that you can't create an intentional infliction of emotional distress case by reframing it basically what's a defamation case, which is what this is. I think that's in essence what the plaintiffs tried to do. But also let's look at Dr. Adewale's conduct. As he himself notes, the moment he was aware of the problem, he immediately corrected the record. In other words, that's not the act of somebody who's recklessly disregarding somebody's rights. It's the act of somebody trying to make sure that the most accurate information is available for the future. And that's consistent with what you would expect of doctors and the law.
What about the argument of opposing counsel that your client had a non-delegable duty to assure that this fact of HIV remained confidential against all prying eyes throughout the hospital in perpetuity?
I think that's a good question, Your Honor, although mostly I'm a hospital attorney, when I hear non-delegable duty, especially from you.
Begin to twitch a little, don't you?
A little bit. It's changed my life a little, but in a good way.
We won't disclose that to anyone.
Thank you. I don't think that the law creates a non-delegable duty for our doctor here, and for a couple of reasons. In essence, the doctor is providing only the physician services that the hospital has, but the hospital records are created by the hospital for the treatment of that patient. There's no non-delegable duty from our doctor as he's making a notation in the hospital's records to tell the hospital how to use those records. And I really don't think there can be, because our doctor never had the original obligation to create or set the record. It was the hospital's obligation to create or set that record. Now, there may be an allegation that he did that negligently. And indeed, had he have done that negligently and physical harm had been caused in some way, if he had acted some way negligently as a doctor and caused physical harm, the impact rule might not apply, and then we might have a different situation. But that did not happen here. If, for example, he had made a misdiagnosis of Mr. Johnson, and Mr. Johnson subsequently suffered a personal injury, there would be a conventional medical malpractice case. And in fact, that's the first thing the plaintiff pled in this case, and Judge Adams, the first judge to consider this case, properly dismissed it, because there was, in fact, no physical injury here. There was only the emotional damages. This is a very unfortunate event because I think everybody agrees that somewhere along the line, this information probably got out into the community. We have affidavits to that effect. We have a lot of information that Mr. Johnson personally was upset about this. But the question is, where is the causal link with Dr. Adewale, who carried out his responsibilities, made notations that he reasonably expected would never be released to anybody else from a hospital's confidential record? Somebody breached that duty, but it wasn't Dr. Adewale. If there aren't,
does the plaintiff have a claim against the hospital?
Your Honor, I not only think the plaintiff had a claim against the hospital, I was briefly the hospital's lawyer when they did have a claim against him, and the settlement agreement for that is put in this cause of action. I think that there is a concern when any nurse would choose to reveal the confidential information of a patient, whether it's true or false.
So the remedy here, in your mind, if there is one, is that because it's a hospital record, unless the doctor is the one who breaches the confidentiality, if that confidentiality gets breached and it was the hospital's statutory duty to maintain it, then the claim in your mind is solely against the hospital and perhaps the leaker, if you can find the leaker.
Yes, Your Honor, and that's precisely why originally in this case I focused on what in libel is called publication, but in the case of Gracie versus Eaker is disclosure. And either way, there has to be a disclosure to some third party. The recent case from the 4th District Court of Appeal, which was not cited in our briefs, but is at 41 Southern 3rd, 320, and I will do a notice of supplemental authority, goes into this a little bit because they take the Gracie...
41 Southern 3rd what?
Southern 3rd, 320, and it's from your sister court, the 4th District Court of Appeal. They deal with a Gracie versus Eaker claim where there was a truthful notation in the record of positive HIV status, which the plaintiff claimed was revealed to her minor children, to third parties who were not entitled to it. However, there was never any evidence in the case of that, and the court said without any evidence of this disclosure to a third party, there can't be any liability on the individual for the disclosure occurring. We have exactly that situation here. There's no evidence whatsoever that Dr. Alawali inappropriately disclosed this information to a third party. Therefore, the trial judge properly granted summary judgment and properly denied the motion to amend.
The opposing counsel contends that once he put it in the records and it was seen by other employees in the hospital, that's publication. I think that's what I understood him to say. And your response to that's what?
I think that there's an exception for situations when people are working in a common cause, as is in the case in the hospital care. They are all actively working for the same purpose, which is to protect Mr. Johnson's health and safety. And therefore, it's not a disclosure to an individual that's in the public. And especially that's true in a medical record, which is not a public document. I will be candid. There are jurisdictions that might consider this a publication and apply a qualified privilege. But even if we were in one of those jurisdictions, Your Honor, they would have to show active malice by Dr. Adewale before they could breach the qualified privilege. Once again, Dr. Adewale never intended to harm Mr. Johnson, so there's no breach of a qualified privilege either. However, our original argument was that publication, the old common law rule that was applied first in Thornburg versus Long, is the right one. It's the same rule applied in DEW versus Krause, and I think it's the rule that Florida should recognize in the case of medical records. I did want to leave some time for Dr. Ranadive's counsel because I promised him I would.
Okay, that's fine, but let me ask you this question. In Section 381.004, there's this couple of sentences. Whenever disclosure is made pursuant to this subsection, it shall be accompanied by a statement in writing which includes the following or substantially similar language. Quote, this information has been disclosed to you from records whose confidentiality is protected by state law. State law prohibits you from making any further disclosure of such information without the specific written consent of the person to whom such information pertains or is otherwise permitted by state law. Is there any comment like that in the record, in the medical record?
No, Your Honor, there is not.
Should there be?
No, Your Honor. No, Your Honor, there should not be, but the reason is both specific and general. Specifically, there's no test or HIV test that was ordered in this case, and so the statute's terms were never technically triggered. But secondly, and more generally, in this case, from Dr. Alawali's perspective, the triage nurse is generally noting the comments of the individual themselves. In other words, the individual comes in and gives their history. From Dr. Adewale's perspective, he believed this was a history given by Mr. Johnson himself. So there would have been no need for him to disclose that you shouldn't disclose your own records to others.
So there's no requirement that the medical record itself have that cautionary language somewhere in them so that prying eyes who do see it understand that they're violating the law?
Not in this case, and Your Honor, I would have to go outside the record on appeal to tell you the kinds of...
No.
Okay. There are significant... in general, healthcare providers do not want these records released, and there are significant procedural steps they take to make sure that happened. For some reason, in this case, for Florida Hospital, that didn't work. But that wasn't Dr. Adewale's doing, and as his affidavit shows, he never revealed it to anyone other than documenting it in the record.
if you want to save some time for your co-counsel, I think he has like 30 seconds left, so.
Great, thank you.
30 seconds.
I think a little more than
Judge, my name is John Bocchino. I represent Dr. RANADIVE. Dr. RANADIVE was a cardiologist who was brought in because of the patients presenting symptomatology and complaints, and he did pick up this information out of the chart. The information was placed in his dictated consultation report, which was 3 pages, and then it was also written in a progress note. I want to more address the questions that the court has brought up with appellant's counsel and with Mr. Holt as well. First of all, it's our position that 381004 doesn't apply to this case, because if you look clearly on 381.004, it says it is the dealing with HIV test results. That never was the situation in this case. Nobody took an HIV test result. Neither Dr. Adewale nor Dr. RANADIVE got an HIV test result and reported to anyone. That's not the situation we're dealing with. The plaintiffs in the lower court, not once but twice, tried to argue that this is a statutory cause of action. And in fact, plaintiffs' counsel says in their appeal that their cause of action is based on common law. But in fact, in their motion to amend, most specifically paragraph 13 of that motion to amend, that indicated that the basis for the amendment was again revisiting 381.004 and 395.3025. And I want to turn to that statute, Judge, because I think it answers your questions. If you look at 395.3025, I'm not really sure why they're citing that. But in fact, that statute, along with the Medical Practice Act, cites the obligation of these physicians to document their thoughts, their process, their history getting in the patient's medical chart, which they did. Then if you look at 395.3025, under subparagraph 4, subparagraph A, it says, patient records, and this deals with hospitals maintaining records because it's hospital licensing and regulation. It says, patient records are confidential and must not be disclosed without the consent of the patient or his or her legal representative, but appropriate disclosure may be made without such consent to, and then there's A, licensed facility personnel, attending physicians, or other healthcare practitioners. Thus, this statute tells doctors, tells other healthcare providers, nurses, whatever, that they are to write in the patient's chart so that information is available for other healthcare providers to see and consider when they're taking care of a patient. This issue that you asked counsel for appellants about, how did this get out? I will unfortunately admit right now that I was trial counsel as well. So that may prompt some different questions. The record below does demonstrate that at one juncture, there was a claim brought against Florida Hospital for this case. There are motions, and there were motions to get the settlement documents. There was a claim brought, and the claim was resolved. The person who documented erroneously that started the ball rolling was a Florida Hospital personnel. The people who supposedly shared this information, and it's not clear who they were. Were they unauthorized people, people who shouldn't be looking in the chart, or people who should be looking to the chart, who are able to look in the chart, healthcare practitioners? It's not clear. In 3 years, there was no discovery taken by the plaintiffs to uncover this issue. But the point is, these people, there is no claim in the complaint, the second or the third amended complaint, for non-delegable duty. There's no claim that these doctors were responsible for subsequent healthcare providers. And then that belabors the next point. If they were unauthorized personnel, how can there be, and I also deal with hospitals and non-delegable duty claims, are we now going to send non-delegable duty claims to janitorial staff, to cleaning staff, against doctors and or hospitals? The point is, the people who communicated or published this information were the hospital. There was no publication by these doctors. And what plaintiff's counsel wants to do and wants to argue in this case, to create a cause of action, will have a chilling effect on medicine. I was sitting there listening, and the only things I can think of would be, every chart has to be kept under lock and key because you don't know what's sensitive in there. And every discussion about a patient, doctor to doctor in the hall, doctor to nurse at the nursing station, nurse to nurse in the hall, before those discussions can take place, the cone of silence must descend, and they can't talk about it and make sure no one can hear. How can patients be cared for? It's literally impossible. This is too onerous an obligation that they are attempting to create. The trial court judge, Judge Evans, looked at this. He analyzed it. The case law is clear. He ruled that there was not outrageous conduct in this case for the intentional infliction of emotional distress. All the proposed arguments the plaintiffs were asserting to amend their complaint all failed for one reason or another. Thus, any amendment would have been futile. And under that lay of the land, so to speak, did Judge Evans abuse his discretion in denying the motion to amend? The motion to continue was only predicated to get the motion to amend. Did he abuse discretion? The evidence is no. There was no evidence presented whatsoever of publication by either of these doctors. And then that leaves us, was the judge's decision reasonable on the remaining sole claim, intentional infliction of emotional distress? You've seen the cases that Dr. Adewale has cited, that we have cited. What constitutes outrageous conduct? Physicians documenting in a patient chart information from another healthcare practitioner and putting it in that chart for that patient's care is far from outrageous conduct. And then if you look at the second amended complaint in this case, attached to that second amended complaint, when this situation came to light to these two physicians, were two letters. One from Dr. Adewale apologizing to the patient, one from Dr. RANADIVE to Florida Hospital Risk Management apologizing for this, both explaining that this was picked up from the chart. Judge Evans ruled that this didn't constitute outrageous conduct. That was a reasonable decision based on the evidence or lack thereof that was before him. We ask you to affirm the lower court's ruling as to Dr. RANADIVE and also as to Dr. Adewale. Thank you.
All right, thank you, counsel. Well argued on both sides. We are at the end of our agenda, so we will be in recess.
Thank you both.